I think this is the largest calendar I've had in probably 2 months now. Okay, we are ready to proceed. And for everyone who's present, I'm here to answer any question that you may have. But we got a large calendar today, and I perform everything directly. So I do the paperwork. So the longer that this hearing lasts, the longer it's going to take for you to get bonded out, because the sheriff's office does not start operating on the paperwork until I send it back. So if I'm in this hearing till 3 o'clock, I won't start doing the paperwork until 3 o'clock. And that means it generally takes me about 2 hours. So that means you're gonna, just extend your time in jail unnecessarily. So I'm here to answer any question, but be mindful of that fact. Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County.
Muy buenos días a todos. Esta es su comparecencia inicial ante el Tribunal de Primera Instancia del Condado de Clayton.
My name is Brad Gardner, and I'm a judge in this court.
Mi nombre es Brad Gardner y yo soy un juez en este tribunal.
I'm here to inform you of the charges that have been filed against you,
Yo estoy acá para informarle de cuáles son los cargos que se le han imputado,
to advise you of certain rights,
para decirle cuáles son sus derechos,
to set bail on those offenses that I'm authorized to set bail,
para otorgarle fianza en aquellos delitos que se me permite otorgarle fianza,
to schedule a preliminary hearing,
para programar una audiencia preliminar
and to determine whether you require the assistance of an attorney.
y para determinar si usted requiere la asistencia de un abogado.
You have the right to remain silent and say nothing.
Usted tiene el derecho de permanecer en silencio y no decir nada.
But should you give up this right, anything you say during this proceeding may be used against you.
Pero si usted renuncia a este derecho, cualquier cosa que usted diga durante este proceso podría ser usada en su contra.
So please don't discuss the facts of your case.
O sea que por favor no hable de cómo ocurrieron los hechos en su caso.
During this and all other proceedings, you have the following rights:
Durante este y todos los procesos siguientes, usted
Sí.
tiene los siguientes derechos:
to the presumption of innocence,
a la presunción de inocencia,
to indictment by a grand jury for most felonies or by accusation for misdemeanors,
de que se le formule una acusación por el gran jurado para la mayoría de los delitos graves o que se le formule una acusación para un delito menor,
to a speedy and public trial by jury,
de tener un juicio público, rápido y por jurado,
to see, hear, and question witnesses who are called to testify against you,
de ver, escuchar y contrainterrogar a cualquier testigo que sea citado a testificar en su contra,
to compel the attendance of witnesses to testify on your behalf,
de exigir la asistencia de los testigos para que testifiquen a su favor,
to testify on your own behalf or offer evidence in your own defense,
de testificar a su favor o de presentar pruebas para ser usadas en su defensa,
and to have an attorney represent you.
y de tener un abogado para que lo represente.
If you cannot afford an attorney, one can be appointed to represent you if you qualify.
Si usted no pudiera contratarse un abogado, se le podría nombrar uno si usted califica.
Some of you will be allowed to post unrestricted bonds for your release from jail.
Alguno de ustedes se le va a permitir que pague fianza sin restricciones para permitirle salir de la cárcel.
These bonds may be posted by cash, commercial, or property.
Estas fianzas podrían ser pagadas en efectivo, usando una compañía de fianza o usando una propiedad.
Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places.
Algunos de ustedes van a tener condiciones especiales en su fianza donde se le prohíbe ponerse en contacto con ciertas personas o de que vayan a ciertos lugares.
You will also be prohibited from contacting the victim while you are in jail.
A usted también se le va a prohibir que se ponga en contacto con la víctima mientras usted esté encarcelado.
If you violate the court's order, your bond will be revoked and you can remain in jail until your trial.
Si usted no cumple la orden del juez, su fianza podría ser revocada y usted tendría que permanecer encarcelado hasta que usted vaya a juicio.
You could also receive additional felony charges.
Y también se le podrían imputar cargos adicionales por delitos graves.
It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond.
Es importante saber que si una persona está nombrada como la víctima en su caso, a esa persona no se le va a permitir pagar la fianza por usted.
Some of you are charged with offenses for which this court is not authorized by law to set bail.
Alguno de ustedes se le acusa de delitos por los cuales, por ley, a este juez no se le permite otorgarle fianza.
In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date.
En este caso, una audiencia para pedir fianza sería programada ante un juez del Tribunal Superior del Condado de Clayton y a usted se le va a informar de cuándo sería esa fecha.
If you are currently on active probation, this court is not authorized to set bond at this time.
Si actualmente usted está bajo libertad condicional, a este juez no se le permite otorgarle fianza en estos momentos.
Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest.
Si la fianza es apropiada en su caso, sería tomada en consideración nuevamente después que el agente de libertad condicional haya tenido la oportunidad de tomar en consideración este nuevo arresto.
The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you.
El propósito de una audiencia preliminar es determinar si hay suficientes pruebas para sustentar las alegaciones en su contra.
The standard at this stage is very low.
Y el estándar en esta etapa es muy bajo.
A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred.
Para que un juez determine que un cargo procede en esta etapa, solamente tiene que determinar que existe la posibilidad de que el delito fue cometido.
Everyone has the ability to waive their right to a preliminary hearing.
Todos tienen la habilidad de renunciar a su derecho de tener una audiencia preliminar.
However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing.
Sin embargo, usted debe de hablar con un abogado primero si usted no está seguro si es apropiado renunciar a tener su audiencia preliminar.
If you post bond, your preliminary hearing is automatically waived.
Si usted paga su fianza, su audiencia preliminar se cancela automáticamente.
You will receive notice at the address you give of your next court date.
Y usted recibiría una notificación en la dirección que usted dé de cuándo sería su próxima corte.
Lastly, I need everyone to raise your right hand, please.
Y finalmente, yo necesito que todos levanten su mano derecha, por favor.
Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God?
Jura usted y afirma que cualquier declaración que usted dé durante este proceso va a ser la verdad, toda la verdad y nada más que la verdad lo jura ante Dios.
Okay, so the cases that I have on my list of where we're calling out of order, we're going to start with Solus needing Spanish interpretation services. We're going to then go to Mr. Tribble. After Mr. Tribble, it's going to be Mr. Dodson. Then after Mr. Dodson, it's going to be Mr. Lamar. And then we're going to switch back into regular order, going back over to the females.
Mr. Salazar.
Okay. Sir, can you hear and understand the interpreter?
Señor, ¿puede usted escuchar y entender a la intérprete?
Sí.
Yes.
Sir, you're charged with one count of driving a vehicle without a valid license.
Señora, usted se le acusa de un cargo de conducir un vehículo sin tener licencia de conducir válida.
Sí,
The
Yes.
bond is set by schedule, which means it's automatically set at $1,000.
Su fianza está fija por ley, lo que significa que está fija de manera automática a $1,000.
I did not receive a copy of your warrant, which tells me that your family members may have already tried to post your bond.
Yo no recibí una copia de su orden de arresto, lo que significa que algunos de sus parientes pueden ser que hayan tratado de haber pagado su fianza.
sí, desde ayer.
Yes, since yesterday.
Okay, so what's probably going to happen is when you leave this proceeding, there's going to be a knock at the door telling you to pack your stuff to leave.
Probablemente lo que va a ocurrir es que cuando usted termine de esta audiencia, le van a tocar la puerta y le van a decir que empaque sus cosas porque se va a marchar.
Since you're here, do you want me to see if you qualify for the appointment of a lawyer?
Pero porque ya usted está acá, ¿usted quiere que yo vea si usted califica para nombrarle un abogado?
No,
No.
Okay, do you have any questions for me, Mr. Solis?
¿Tiene usted alguna pregunta para mí, señor Solís?
no.
No.
Okay, sir, you're free to go back.
Ok, señor, puede retirarse.
Gracias.
Thank you.
Thank you, Ms. Bermudez. I think that ends my need for your services today.
Thank you, Judge. Have a good weekend, and I hope that you get some rest.
I'm going to do my best.
Yes, sir. Have a good one.
You too.
Thank you.
Mr. Tribble.
Here you come, John.
I'm sorry. So, Mr. Tribble, sir, I would normally speak to you directly, but you've taken advantage of the opportunity to hire a lawyer, Mr. Hazen. So I am going to speak to him instead of you, but I want to caution you that anything you say over this proceeding is not privilege. So don't say anything you don't want the whole world to know. Do you understand that, sir? Okay, so Mr. Hazen, your client is charged with one count of aggravated battery, one count of disorderly conduct, one count of, it says mask wearing on the bond order, but I don't know what that means, and one count of criminal trespass, damage to property. I will hear from you about your client and about bond.
Okay, he is 19 years of age, Your Honor. He was born in the Atlanta area. He's lived here all of his life. He currently lives with his mother on Seabright Lane in College Park. He has other family members here in the Atlanta area also. So in terms of contacts, this is the place that he lives.
Okay.
He's a student. He's a sophomore at Clayton State University. He's studying film production. He apparently, my understanding is that this case involves some kind of a fist fight between him and another student at Clayton State University. We received a telephone call yesterday from investigator Ahmad indicating that there was a warrant for his arrest, and about an hour and a half or 2 hours later, he turned himself in voluntarily. So I don't think he's going anywhere, again, because he's got contacts. When I spoke with investigator Ahmad yesterday, he indicated to me he thought there was actually a bond set on all of the charges except for the aggravated battery. And hopefully that's the case. And I asked him for the basis for the aggravated battery charge, and it was basically his fisticuffs. I don't think there were any weapons that were used in this particular case. I also asked about the mask wearing situation because I was also confused about that, especially in as much as we're all wearing masks these days. This apparently was some kind of a ski mask that was on. I haven't seen it, but that's the information I have. I'm in the case. I have no doubt that he will turn up to court when he needs to turn up to court. And I would ask that the court set a reasonable bond on the aggravated battery charge and the others if no bond has been set on those charges.
I do not have an indication that bond has been set on. The only charge is the disorderly conduct. The bond has been set at $1,500. What I'll do, it looks like the aggravated battery is based upon the allegation of a broken jaw, which I think that fits your characterization of a fist fight. So I'm going to set a $5,000 bond on the aggravated battery, a $1,500 bond on disorderly conduct, a $1,000 bond on the ski mask wearing charge. I'm sorry, and a $2,000 bond on criminal trespass damage to property. So that's going to leave your client with a total bond of $9,500. There's going to be a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your client bonding out, and he'll get a new court date in the mail. Is there anything else you want to tell me about your client, Mr. Hayes?
No, I think that's it, Your Honor.
Okay.
I anticipate he will be able to make the bond.
Okay.
Certainly prior to the probable cause hearing.
Okay. All right. So, Mr. Hazen, you're free to go. Mr. Tribble, you're free to go back.
Thank you, Your Honor.
You're welcome. Have a good day, sir. Let's see. The next person is Mr. Dodson.
There you go. I'll just do it.
So, Mr. Dodson, sir, I'll give you the same admonition that normally I would speak to you directly, but you take advantage of the privilege of hiring a lawyer. So I'm going to speak to Mr. Florio. Do not say anything that you do not want the whole world to know. Do you understand that, sir? Okay. Mr. Florio, tell me about your client.
So, Judge, this is an allegation of an incident that occurred at some point last year, essentially from having reviewed the records in this matter and also speaking with the alleged victim is Brandy Carter. I think there's an allegation of a largely a domestic dispute between she and Mr. Dodson, I think in December. Obviously, there were warrants issued for Mr. Dodson. He had no idea that he was wanted. He and Ms. Carter are, to be in full candor, they're still in a relationship. They saw each other yesterday. And so he's had no idea that since December of last year, that there were these warrants for his arrest and these allegations having been made against him. Ms. Carter and I have spoken. She was the one who reached out to me regarding Mr. Dodson and my representation in this matter. She herself evidently was arrested last year. And she explained to me that she believed she was arrested because at some point during law enforcement's investigation, she became uncooperative with law enforcement. And so she believed that that was the basis for her arrest in this. I certainly cannot certify that that is the case, but I do see that Ms. Carter herself was arrested on what appears to be a marijuana charge. And she relayed to me that the reason for that, and obviously I've done no investigation, but she relayed to me the reason for that was law enforcement contacted her regarding Mr. Dodson. And when she was uncooperative, evidently she had an amount of marijuana on her. And she claims that law enforcement said, well, if you're not willing to talk with us regarding him, then we're going to charge you for this marijuana. I see that there obviously are records supporting her arrest and her arrest for a marijuana charge. She's identified to me as that being the basis. Having said that, Your Honor, Mr. Dodson's 34 years old. He works in the roofing industry here in Metro Atlanta. He has 6 children, all of whom he's present in their lives and financially responsible for. And he works hard and works a lot to provide for his family. He lives in Stockbridge. He has a brother who I'm very familiar with, who also resides here in the Metro Atlanta area, and Mr. Dodson himself is born and raised here. He's involved in the community to the extent that he coaches kickball, both in an adult league and also in a league with children as well. I obviously, I don't have the warrant paperwork in the police reports, and certainly we haven't been able to done the investigation that we will do in this case. But going back to statements from Ms. Carter has alleged that she never told law enforcement that Mr. Dodson in fact strangled her. I think she told law enforcement that there was a struggle between the two. And certainly that would form the basis, I believe, of the battery charge. But she's intimated to me that he did not commit a strangulation, and that she reached out to law enforcement after this to indicate that to them. And also has indicated that there was no firearm involved in this offense. The fact that he's charged with pointing a pistol at another and not aggravated assault always, it seems inconsistent sometimes that he would be charged with pointing a pistol but not aggravated assault. Because typically, more often than not, if you point a pistol, there would be an aggravated assault charge. She's indicated to me that there was no gun involved in this, that there was a gun in the home, and that I believe law enforcement recovered that gun, but that there was no gun involved in this dispute. She, I think, does make clear that Mr. Dodson put his hands on her, but disputes these other charges as alleged.
Can I stop you for a second, Mr.
Yes,
Florio? So I did set bond preliminarily for Mr. Dodson. And the total bond was $45,000, $5,000 for the battery, $10,000 for pointing a pistol gun at another. Aggravated assault by strangulation is $20,000, and possession of firearm during the commission of a crime is at $10,000. Now,
yes, sir.
I'm willing to engage in a conversation with you about these bond amounts based upon what you're saying, but I also want Mr. Dodson to hear this and to take into account from the judge's standpoint. Based upon what I heard from you, this person that Mr. Dodson, Ms. Carter, who there's going to be a stay away provision as it relates to Ms. Carter, that they were together yesterday, but she made these allegations back in December of 2020, and he didn't know anything about it. And I'm going to take that as all being true. When it gets into the where they're lying about this, lying about that, that kind of stuff, I kind of, that's what trials are for, right? For Mr. Dodson's benefit, I hope that he hears that if he's been with the person and been around the person, and that person called the police, and that person knew they called the police. Now, whatever the police do is what the police do, but once you call the police, you're inviting other people into your life. So sometimes I tell people that the stay away provision is to help you, because if you're not around that person, that you're essentially saying lied upon you to the extent that you're being arrested. If you're not around that person, that's going to help you. So I'm always willing to help you by telling you to stay away from that person, that based upon your recitation of the facts, that person is a liar that has no problem in getting you arrested. So let's talk about bond amounts.
Judge, can I ask the court, the possession of a firearm during the commission of a crime, what crime was alleged in that warrant?
It just has to be a felony. I mean, and that's in my, well, I gotta, I'm a judge. I have to be mindful.
Yes, sir.
There's so many laws on the books that you can get arrested for spitting on the sidewalk, and you get arrested for not spitting on the sidewalk. And so it ultimately comes down to the officer's interpretation. And as you know, once you get into that whole debate and discussions with prosecutors, charges fall away.
Yes,
As
sir.
a judge, I'm just only here to look at the technical aspects of it. So the fact that there is aggravated assault by strangulation and they say that there is a gun involved, that supports the possession of firearm during the commission of a crime, because it has to be a felony. Whether I agree with it or not, it's like I tell people all the time, the way I rule about something today may be totally different if it's a preliminary hearing. And I get to ask questions and I get to, probe. But I will, let me see. I'll answer your question directly. The warrant number for the possession of firearm during the commission of a crime is 2020 CW 56126. And it says that in the midst of committing the crime of aggravated assault by strangulation, that your client is alleged to have had a Taurus 380 on himself and in his possession. So I hear exactly what you're saying.
Yes, sir. I appreciate it.
Yeah.
Your Honor, I think what I would ask is the fact that we're not charged with aggravated assault with the firearm, but only aggravated assault with strangulation. The aggravated assault by strangulation, I would ask that bond be set in the amount of $5,000 because there was not a weapon used to commit that aggravated assault. Possession of a firearm during the commission of a crime, I would ask for a $2,500 bond on that matter, because if you didn't commit an aggravated assault with the gun, then I don't know how you committed the offense of possession of firearm during the commission of a crime. And obviously we did not commit the offense of aggravated assault with the firearm because we're charged with the misdemeanor of pointing a pistol at another and battery. I would ask for a $2,500 bond on the other three. So that would be 25 on both gun charges for $5,000, 25 on the battery, which would be $7,500, and then $5,000 on the aggravated assault strangulation. So I would ask for a total bond of $12,500.
Okay. You're close to what I was thinking.
Yes, sir.
I'm gonna
Yes, sir.
do 5,000 on the battery. I'm gonna leave that.
Yes, sir.
I'm gonna do 5,000 on the aggravated assault by strangulation. And I'll do the 2,500 each on the pistol or the gun charges. So
Yes, sir.
that'll be $15,000.
Thank you, sir.
You're welcome. All right. His preliminary hearing date is going to be set for September 29th, but it's going to get waived upon his bonding out, and he'll get a new court date in the mail.
Yes, sir, Your Honor.
Sorry, I'm sitting here trying to wipe things out. I was a child, my 10-year-old's been running a fever for 3 days. And today, when I'm done with all of the stuff, I'm going to try to take him to get him tested. So I'm kind of out of it a little bit.
Absolutely. Yes,
as
sir.
it relates to stuff. Is there anything else, Mr. Florio?
No, sir, Your Honor. Thank you for that.
Okay. All right, Mr. Florio, you're free to go. And Mr. Dotson, you're free to go back.
Thank you very much, Your Honor. Your Honor,
You're
that
welcome.
concludes my business. Have a good weekend, Judge.
You too. Have a good day. All
Thank
right,
you,
let's
sir.
bring up Mr. Lamar. Mr. Williams, your client is charged with battery. I've set a bond at $5,000 and I've placed a stay away provision on the bond to stay away from Materia Patrick. And Mr. Lamar, let me caution you, as I've cautioned others, anything you say during this proceeding is not privileged. So you've taken advantage of the right to hire a lawyer. Please don't say anything that you would not want the whole world to know. Okay, sir? All right. So Mr. Williams, he has a $5,000 bond for battery, and there's going to be a stay away provision on the bond. But I'll hear from you. Is there anything you want to say about your client as it relates to the charge or bond?
Yes, Your Honor. My client is a 35-year-old resident of Clayton County. He's been in Clayton County for several years now. He has family in Ellenwood, Georgia, and he works as an Uber and Lyft driver and as a personal trainer. He has very significant ties to the community as he's a personal trainer. He's created his own profitable entrepreneur business as a personal trainer, and he trains people throughout Clayton County. He has no prior criminal history. And it's important to note that upon this warrant being issued, that we filed a motion to quash the warrant. Also, I've been trying to get a hearing date for 3 weeks now. I've been down to Clayton County about 6 times, attempting to get a hearing date on that motion to quash. And I don't know if Your Honor has the motion in front of Your Honor, but also the motion was accompanied by an affidavit showing where the officer who took out the warrant or requested the warrant misled the issue judicial officer and important facts. And because of that, Your Honor, we were actually trying to get scheduled, and I spoke to Ms. Mary Moultrie, the clerk, to get scheduled for the motion to quash hearing when Mr. Lamar was arrested yesterday morning at his home. That being said, Your Honor, and graciously appreciating the $5,000 bond that you've issued, but I feel that it's more in line with this case matter if he had an actual signature bond, because we have so many circumstances surrounding the allegations and the warrant that was taken out that we've done our due diligence to show that the officer just did not do his job in investigating the matter to determine that Mr. Lamar was not anywhere close to creating a battery, and at most it was a self-defense. He had restrained the person who was swinging at him repetitively, and that's who wrote the affidavit. And so understand that we will not get a chance to have a preliminary hearing, and there will be more motions to follow after we made the bond. Your Honor, I would ask that he's able to assist in his defense and not have to pay a bond and able to place that money towards defense.
So the way that it goes with they call them unsecured judicial restraint now is the new term for ORA bonds. I would have to get permission from my chief, and she's handling stuff. So the way that it normally goes is that if a person is making that request, I would have to keep that person in jail overnight so that I can have the conversation this evening with my chief about whether she believes that he should get the unsecured judicial release. And she may say yes, she may say no. And I typically tell people, look, I mean, you can make that request, but it's really narrow, the people that fit within that category. To the extent that this is a situation where what I hear you're saying is that you believe there is no probable cause for the warrant to issue. Correct. And I've had a couple hearings like that in my day, with the way that the COVID stuff and everything is doing with courthouses being closed. That's just not something that's easily done. And it doesn't fall on your client's shoulder to the extent that, it does. Like, there's stuff that I set bond for now that I probably wouldn't set bond for when we were having people back in court within 10 days of arrest. So to the extent that people are getting out for stuff that I really wanted to see it before a preliminary hearing, your client may be on the other side of that, where he may have to just surrender, post bond, and fight it on the back end. Because you're probably, if you've called the solicitor's office, they probably said, we're not going to speak to you until he turns himself in. So as a lawyer, you're in that position of you're trying to advocate for what you are trying to do for your client, which we all understand. Trying to do kind of what works best for everybody. Like when I tell people when I'm setting bond, I have to think about public safety. You're presumed innocent, but I also have to think about public safety. So it's like, well, what if this person did it? Then how do I protect the public? How can I craft a solution to protect the public? What I would suggest to you is this. To the extent that this alleged victim, because she's the alleged victim and your client is the alleged, well, he's the offender, but he's has cloaked with the presumption of innocence. If the alleged victim is not going to come off the story that she said, you're kind of teeing this up for trial, because that's the hello.
Yes, Your Honor. Sorry.
Okay. It's like you're teeing this up for trial, because that's the only place to get that kind of resolution, unless there are video cameras, there's something that you have that is absolute proof. Because first thing the solicitor's office is going to do is they're going to call the alleged victim. And if she says, no, he did it, then they're saying, well, hey, she said he did it. We're going to put it before a jury.
She's actually saying he didn't do it. She actually told the officer at the hospital that my client never struck her, that she did all the striking, that she did all the swinging, that all he did was restrain her. And the officer did not include that in the warrant. And that's the issue, is that the officer didn't include very, very pertinent information. And I think if the judicial officer would have known that this young lady admitted that she went through my client's personal property, she then got upset, she then swung at him, she continued to swing at him, my client then restrained her, she starts kicking, they fall to the ground. My client lets her go, she starts hitting him again. My client never hit her. If that's what she says, that's the issue.
Well, that's what she is telling you today. Well, and I'll say this from this standpoint. Have you gotten the body worn camera from the officer?
I've submitted an open records request, Your Honor. I have not gotten it, but I have spoken to the officer, who also stated that, yes, she did tell me that, and I don't know why I did not put it in the probable cause request. That's what the officer actually told me out of his own mouth. And the officer, and there was also another witness that was sitting there when she was getting her statement. Her sister was sitting there, who also she told him that she swung at him first, and the officer said that he was going to arrest the alleged victim, but then after speaking to my client said, well, he has a shitty attitude, and so I'm going to arrest him.
So I'll do this. And so the officer is Brandon Marshall.
Correct.
So $1,000 is the lowest amount I could set a bond where a bonding company will come in on the bond. I'll set a bond at $1,000. That's going to be probably $150 that your client will have to pay to bond himself out. And I'm basing this upon the representations that you've made to me here today. Half of my calendar is like batteries, simple batteries, simple assault, criminal trespass, where it's adults acting like children. For your client, to the extent that I'm taking everything that you've told me as being true, your client may need to stay away from this lady.
And we spoke about that extent yesterday, Your Honor. I came down to see him at the jail, and we spoke about that in extent, because obviously we know what happens if if she calls the cops again with the stay away order in place, and then that becomes aggravated stalking or whatever, I definitely spoke to him about that, especially while this is pending. There's a big age. My client is 35, and this young lady, I think, is 23. That's a lot.
Yes, I could totally, just from all of the allegations, I could totally see that. So the thing is, and I tell people, I've been married to my wife for 19 years. First time she calls the police about an argument that we have, that's going to be the end of our relationship. And we've had a discussion about that. You're going to have disagreements in relationships. That's just how relationships work. But when people start calling the police, they start bringing other people in. I tell, based upon the representation you made to me today, I was like, the police don't go down the street knocking on doors saying, who can I arrest today? If there's somebody I can arrest in there, they get called out. And once they get called out, you're going to have to live with whatever decision they make, whether it's right or wrong.
Correct.
Okay. So preliminary hearing day is going to be set for September 28th at 8:30 in the morning. That date's going to get waived upon his bonding out, and he'll get a new court date in the mail. There is going to be a stay away provision to stay away from Miss Patrick and Mr. Lamar. I would suggest you listen to your lawyer as it relates to that, because if you don't, and she allows you in 9 times out of 10, that 1 time out of 10 that she gets upset with you, that's aggravated stalking charges, and you're going to sit in jail, because I can't set bond on aggravated stalking. So I don't know anything that's worth sitting in jail for, but you should really take that under consideration. Okay, sir? All right. You're free to go back. Ms. Williams, you're free to go.
Thank you, Your Honor. Have a good day.
You too. Okay, let's switch over to the ladies' side.
We're ready, Judge.
Okay, so the first person I have, I believe it was either Courtney Michelle Ashley or Courtney Michelle Washington. Is that what you're reflecting?
It's the same, Your Honor. One is a married name, one is a maiden name. But it's the
Okay.
same person.
Okay, so you want me to treat her as a Ashley or a Washington?
Washington.
Okay. Okay. Okay, let's deal with Miss Candio. And I'm going to try to pick up the pace because we're almost into noon, and I don't want you all sitting in jail for no reason. Miss Candio, ma'am, you're charged with 1 count of criminal damage to property in the 2nd degree. The bond's going to be set at $5,000. Do you believe you can post that bond?
I'm sorry. What did you say?
Are you Miss Candio?
Uh-huh.
You've been charged with 1 count of criminal damage to property in the 2nd degree. Bond's going to be set at $5,000. Do you believe you can post that bond?
No, sir. Is there a way you can lower it for me, please?
All right. Give me 1 second. I'm going to come back to that. There's going to be a stay away provision on this bond to stay away from a Shantavia Jones. Do you understand that?
Who is that?
Okay.
That's the person that's the alleged victim in this case. Okay. So the allegation is that you threw an iPad that cost $560 and a tablet that cost $264 and broke both of them. That you got in a verbal argument with the victim, who is Miss Jones, about throwing the victim's food away. Does that any of this stuff ring a bell to you?
No, sir.
Okay.
That didn't happen.
Okay. That you forcibly entered her bedroom, took the iPad off the bed, threw it on the ground.
No, sir.
So, ma'am, you're presumed innocent I'm not asking you if you
Okay.
did it. You said you don't know who this person is. You don't know nothing. You Miss Candio, I don't know nothing. So do you recall going into a bedroom
No,
ever in your life no, I don't say ever in your life. Do you recall going into a bedroom on August 12th of this year?
yes, my home.
Okay.
At my house.
Okay. So ma'am, so you do understand.
I understand. What I understand is why the charges are being placed, but I understand. Can you please lower the bond for me and then we can move forward?
Why?
Because I do not have $5,000 cash right now.
Were you in control of your hands on August 12th?
Yes.
So ma'am, if you were in better control of your hands, you wouldn't appear before me right now. So the answer is no, ma'am. You're gonna have a preliminary hearing date set for September 29th because these are felony charges.
Okay.
And if you post bond is gonna, that preliminary hearing date is gonna get changed. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay, you do qualify. I'm appointing a lawyer to represent you. You're free to go back, ma'am.
What about the bond?
I said no, ma'am. Control your hands, control your body, control yourself so that you never see me again in your life.
Sir, I'm confused though. You just say $5,000.
Yes, that's your bond amount.
Okay, I posted with the bond.
I'm like, she don't know. It's her. You're like, yeah, that's my house. Yeah, says you went into the room and broke the lady's iPad and tablet. I know.
We're ready to proceed, Judge.
Thank you. And I do apologize. I'm really at a low tolerance level today.
That's understandable, Your Honor. We've had conversations.
Okay. All right. Ms. Carter.
Ms. Carter. So the way, Judge.
Ma'am, you're charged with a red light violation. Bond is going to be set at $500. You're charged with driving a vehicle with no insurance. Bond is going to be set at $1,000. You're charged with one count of violation, Georgia Controlled Substance Act. Bond is going to be set at $3,000. And crossing the guard line with drugs, bond is going to be set at $3,000. So you're going to have a total bond set at $7,500. You believe you can post that bond, ma'am?
Yes.
These are felony offenses, so you're going to be given a preliminary hearing date for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. You're gonna hire your own lawyer, you're gonna represent yourself.
Yes, sir. I have my own lawyer.
I'm sorry, ma'am.
I said, yes, sir. I have my own lawyer.
Okay. Do you have any questions of me?
No, sir.
Okay, ma'am. Free to go back. Ms. Duncan.
So she's on her red line.
I'm sorry. Ms. Duncan, ma'am, you've been charged with one count of criminal damage to property in the second degree and one count of family violence battery. You're going to have a total bond set at $8,000. Do you believe you can post that bond?
No.
Okay. There's going to be a stay away provision on the bond, stay away from a Terrell Duncan. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. I hope your son feels better.
Thank you. Have a good day, ma'am. Ms. Gentry? Okay, Ms. Gentry, I believe your daughter and your son-in-law appeared before me last week, and your daughter was really concerned about your welfare, and I told her that I would look out to see when this case comes across. So I'm setting a bond of $1,000. That's the lowest amount I can set that a bonding company can set a bond for. Do you believe you can post that bond, ma'am?
Sir.
Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I already have one.
Okay. Do you have any questions for me, ma'am?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Let's see, Miss Ingram. Okay. Miss Ingram, ma'am, you're charged with one count of battery and one count of, well, actually 2 counts of battery. Your bond is going to be set at a total bond of $10,000, $5,000 a piece. Do you believe you can post that bond, ma'am?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a Charles Ingram and a Carmen Marchman. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Give me 1 second. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Can you repeat that amount again for me, please?
It's going to be a total bond of $10,000, $5,000 for each count.
Okay.
Okay, free to go back, ma'am. Is it Miss Pilgrim? Okay, ma'am, you've been charged with 2 counts of simple assault. I've set the bond at $3,000 a piece for each count. So there's going to be a total bond of $6,000. Do you believe you can post that bond?
Yes.
There's going to be, which I don't know why I didn't do it. All right, so I can barely read the handwriting of the officer, so I'm not going to place a stay away provision on the bond. You're going to have a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Let me do it this way. Are you currently working, ma'am?
No work?
Are you currently working?
No, not right now.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, ma'am, let me leave you with this thought. The handwriting by the officer is super small. I can barely make it out. I can't see who the officer is saying is the victim. It looks like a Deshauna Jones, but I don't know. Does the last name Jones, does that ring a bell with you?
Yeah, that's my mother.
Okay. So you're going to be released without a stay away provision, which normally calls for phone calls from the solicitor's office this evening. Because you show back up at home and the other person is like, why are you here? They then start calling. You need to understand that govern yourself accordingly, because if those phone calls start coming, there will be a stay away provision placed on your bond. And you're going to have to leave and you're going to have to do all these other different things. If the officer had better handwriting, it would have been placed already. Don't place yourself in a situation where you're having to have additional involvement with law enforcement. Okay? All right, man. Free to go back. Miss, is it Ross or Rose?
She's coming, Judge.
Okay. Ma'am, you're charged with 1 count of theft by taking, 1 count of fleeing and attempting to elude police, 1 count of improper or erratic lane change, 1 count of driving a vehicle without a license, and 1 count of reckless driving. You're gonna have a $5,000 bond for the theft by taking, $3,000 bond for the fleeing, attempting to elude, $1,500 bond for the erratic lane change, $500 for the license charge, and $2,000 for the reckless driving. So you're gonna have total bond set at $12,000. Do you believe you can post that bond, ma'am?
Yes.
There's going to be a preliminary hearing date set for September 28th at 29th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
No, Your Honor.
Okay. Do you have any questions for me, ma'am?
No, sir.
Okay, you're free to go back. Is it Daniqua Smith?
Yes.
Yes, Judge. She's coming.
Okay.
Good morning.
Good morning, ma'am. You're charged with 1 count of terroristic threats or acts and 1 count of criminal damage to property in the second degree. You're gonna have $3,000 bond set for the terrorist threats or acts and a $5,000 bond set for the criminal damage to property in the second degree for a total bond of $8,000. Do you believe you can post that bond, ma'am?
Yes.
There's going to be a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Thank you.
I think that concludes.
Now we have Miss Washington.
Washington, come on.
Ms. Washington, Your Honor.
Good morning, ma'am. You're charged with 1 count of simple battery. I set the bond at $4,000. Do you believe you can post that bond?
Yes, Your Honor.
There's going to be a stay away provision on the bond to stay away from a Porsche Boykin. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, ma'am, you're free to go back.
That concludes the message, Your Honor.
Thank you for your patience and your indulgence. Have a good weekend.
You do the same. Take care of yourself, Your Honor.
Okay. All right, let's switch over to the mail side.
Come on. Say tonight.
Good morning or good afternoon. My name is LeBron Allen.
Okay, sir, you're charged with 1 count of interference with custody. I've set the bond at $1,500. I'm willing to reduce the bond to $1,000. Would you like for me to do that?
Yes, sir. I actually asked if you could dismiss the case because it was a simple form of miscommunication. I wasn't not only saw, but I've been informed by the alleged victim that there was a TPO in order between my son, me, and Jared, which is the witness on the case.
Right.
They also have multiple domestic violence cases on file between the alleged victim and the witness. After I was informed that there was no TPO in order.
Let me stop you. Let me stop you real quick. I cannot dismiss it at this stage. This is like technical. All that I'm dealing with right now is stuff that shows that the 4 corners of a charge has been met. After reading it and seeing what I saw, I didn't see, it looks as though you could get ultimately to where you're trying to go. But I just can't do that today. So that's why I was saying I even like set it at 1,500. But the reason I was setting that at 1,000 is because that's the lowest amount that you can go through a bonding company.
Okay, I understand and I appreciate it. Thank you.
Yeah, so it doesn't appear, you know, when I looked through it, it doesn't appear to be something that is where possibly you should have been arrested, but that's not the stage for me to make that determination. Okay.
Yes, sir.
So you're going to have a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. All right. I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you, but please speak to the lawyer about the facts of your case because I think you may end up with a good outcome.
Okay, thank you.
You're welcome. All right. You're free to go back. Mr. Anderson.
Good afternoon, Your Honor.
Good afternoon, Mr. Anderson. You've been charged with 1 count of battery, 1 count of robbery. I've set the bond at $5,000 each for these offenses for a total bond of $10,000. Do you believe you can post that bond?
No, sir, I asked that you lower it because that accusation of robbery was with me and my significant other.
So, Mr. Anderson, that's the reason that you're getting a bond, because it honestly, the way that I read it is you and your girlfriend, there's something on her phone that you got upset about and you snatched your phone. That does fit the category of robbery. I mean, I know you may not agree with it, but it does fit that. So I'm gonna leave it the way that it's set. There's going to be a stay away provision to stay away from a Josie is Villa Lagos. These are felony charge. The robbery is a felony charge. And so your preliminary hearing date is going to be set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out. You'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. So from reading it, I understand. I'm telling you, I see it all day, every day. I understand. But the thing that you have to understand is you are an adult and there are consequences for the things that you do. And what you are alleged to have done, it does fit the robbery by sudden snatching.
May I say something, Judge?
Yes, sir.
That she never had lost her phone. I never had her phone, that she had found her phone in the house, so it's like.
It's committed, the crime is completed if the allegation is, let's say she's sitting there on the couch, flipping through her phone, and you take the phone from her. That's robbery by sudden snatching. And I understand how you're like, well, hey, you could say, and I'm not asking you to say, but that was my girl. She's on there. She's on social media. She's doing this, doing that. Boom, 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 boom. All of that stuff could be 100% true, but you still could be charged with the offense. Now, whether you're ultimately convicted, whether the DA's office looks at it a different way and they take it a different way, all of that stuff is beyond me. Okay? All right, sir, you're free to go back. Mr. Brooks.
How you doing?
I'm doing well. Mr. Brooks, you're charged with robbery, theft by taking, battery, simple battery, and exploiting or depriving an elderly person. And I really and truly contemplated not granting you bond on this case. I've granted bond, so we don't need to go down that rabbit hole, okay? It's gonna be $10,000 on the robbery, $2,000 on theft by taking, $5,000 on the simple battery, and $5,000 on the exploiting an elderly person. So that's going to be a total bond of $22,000. You believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, stay away from a James Sullivan. Do you understand that?
Yes, sir.
Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Just thank you for giving me a bond. That's all I gotta say. I appreciate it.
Okay, Mr. Brooks. If these allegations are true, you need to change what you're doing because it's going to catch up to you one day. Okay? All right, sir, you're free to go back. Mr. Carson? Sir, you're charged with 1 count of hit and run and 1 count of driving a vehicle without a license. Your bond for the hit and run or leaving the scene of an accident, bond's going to be set at $3,000. Your bond for driving on a suspended license is going to be set at $1,500 for a total bond of $4,500. Do you believe you can post that bond, sir?
Yes, sir.
There's going to be a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, thank you, sir. I'm getting my own.
Okay. Do you have any questions for me?
Yes, sir.
All right, you're free to go back. Mr. Coakley. Sir, you're charged with 1 count of criminal trespass, 1 count of battery, 1 count of cruelty to children in the 3rd degree. You're gonna have a $3,000 bond on criminal trespass, $5,000 bond on the battery, and a $3,000 bond on the cruelty to children in the 3rd degree. There's gonna be a stay away provision on the bond to stay away from a Brook Ward. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Total amount?
Total amount is going to be $8,000. I'm sorry. It's going to be $11,000.
All right.
Okay, you're free to go back.
Mr. Biggs is next.
Okay, Mr. Diggs. Sir, you're charged with one count of theft by receiving stolen property. I've set the bond at $10,000. Do you believe you can post that bond?
Sir.
I'm sorry, sir.
Yes, sir.
Your preliminary hearing date is going to be set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
How much do you earn per hour or per month?
I don't even have a job no more than I'm in here.
I'm sorry, sir.
I don't have a job anymore than after I got locked up.
I heard locked up, but I didn't hear what came before that.
I no longer have a job.
Okay, I'm just going to find you qualify for representation. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Tell me how to pronounce your last name.
It's the review.
I'm just going to call you sir. Is that fine? Or Mr. Sir, you've been charged with one count of family violence battery. Bond has been set at $5,000. Do you believe you can post that bond?
Sir.
There's going to be a stay away provision on the bond, and I'm gonna certainly mispronounce the name, but it looks like it's Ja Brooks. Okay, there's gonna be a stay away provision to stay away from her. Do you understand that? Your preliminary hearing date is gonna be set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You're close. You're on the edge, but I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir, you're free to go back. Mr. Franklin.
Well, Franklin, come on up, he's coming up.
Okay.
All right. There he is, Jan.
Mr. Franklin, sir, you've been charged with one count of loitering or prowling. Bond is going to be set at $1,000. Do you believe you can post that bond?
Yes, Your Honor.
I'm sorry, sir.
Yes, Your Honor.
There's going to be a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, free to go back.
Gilmer.
Mr. Gilmer.
How you doing?
Hi, sir. You're charged with one count of terroristic threats or acts. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Camila Center. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for September 29th at 8:30 in the morning because this is a felony offense. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
There's one, in regards to the stay away, we have a child together, so I was, trying to see if we get, like, what could I do about, like, getting it into a, what you call it? A no violent contact or either a supervised thing?
That's something that can change. The main purpose of why we put a stay away provision is I don't know you, I don't know her, and I don't know whatever led to you appearing before me today to flare up this evening. So we put a stay away provision on the bond. She can contact the district attorney's office and she can talk to them about how she feel about you. Do you have any kind of orders in place as it relates to custody?
No, and that's why we in this situation now, because I haven't got my baby legitimized yet. So when I do, we won't be like that.
There's, I'll tell you from man to man. If you're not married, get something on paper, because unless and until the child is legitimized and there is a custody plan in place, that's that mother's child. It's not your child. So at any point that she decides that she doesn't want you to see the child, she can say, go about your business. Okay.
Yep.
So get a lawyer and help you through that. And you may be able to talk to the lawyer that I appointed to help you deal with that. Okay.
All right, thank you.
Okay. Mr. Glass.
Here he is, John.
Okay. Mr. Glass, sir, you've been charged with speeding and 2 counts of violation of Georgia Controlled Substance Act. One is possession of more than an ounce of marijuana, which is a felony, and possession with intent to distribute marijuana, which is also a felony. So I've set a bond of $500 for the speeding, $5,000 for the possession of marijuana more than an ounce, and $10,000 for possession with intent to distribute. So that's going to be a total bond of $15,500. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Can you repeat the bond again?
Okay. Total bond is going to be $15,500. There are going to be fees added that Sheriff's Department is required to add fees by Georgia law. So it's going to be a little bit higher than that. Okay. All right. Mr. Hyde.
Read it down.
Sir, you're charged with 1 count of failing to register. I've set the bond at $10,000. You believe you can post that bond? I'm sorry?
Yes, sir.
Your preliminary hearing date is going to be set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. Thank you.
Okay, free to go back. Mr. Is it Johnson or Jackson?
Jackson.
Okay. Mr. Jackson. Sir, you're charged with 1 count of battery, 1 count of false imprisonment, and 1 count of possession of firearm by a convicted felon. I've set the bond at $5,000 for each offense, which is a $15,000 total bond. I was endeavoring to try to place a stay away provision on the bond of a person with the last name of Harris. Okay, so stay away from that person. There's a stamp over the name, so I couldn't read the first name. Your preliminary hearing date is going to be set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right. How much do you earn, either by hour or by month?
I get paid every 2 weeks, $15 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
How much the bond is altogether?
$15,000.
Okay, thank you, sir.
You're welcome. Is it now Jerville Johnson?
There he is.
Okay.
Hi, sir.
Mr. Johnson, sir, you're charged with 1 count of family violence battery, 1 count of criminal trespass, damage to property, 1 count of theft by taking. Sorry, you're gonna have $5,000 bond set for battery, $3,000 bond set for criminal trespass, and a $2,000 bond set for theft by taking. That's gonna leave a total bond of $10,000. You believe you can post that bond, sir? I'm sorry.
Yes, can you repeat?
Okay. Was it, do you want me to repeat it or was it a yes?
Could you repeat it, if you don't mind, sir?
Sure. The bond for the battery charge is $5,000. The bond for the criminal trespass damage to property is $3,000. And the bond for the theft by taking is $2,000. So that's going to be a total bond of $10,000. Do you believe you can post that bond? There's going to be a stay away provision on the bond to stay away from a Victoria justice. Do you understand that?
My baby mother? All the charges should have been dropped. Your Honor, you can continue.
Okay. Do you understand that there's a stay away provision to stay away from Victoria justice? If you violate that, you can get charged with aggravated stalking, and it's a no bond situation. Okay. Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. I was wondering, all those charges was supposed to be dropped, and it was the family violence. It was arguing. It was no discussing your case.
So, Mr. Johnson, when the charges are dropped, you will be the first person to know. Okay.
Can I get in contact with the person and tell them to drop those charges?
No, that's what the stay away provision is
Your
about.
Honor, if he has any more questions, I'll answer.
Okay, thank you. Mr. Tyquavius Jones? So, sir, you're charged with speeding, reckless driving, concealing the identity of a motor vehicle, improper lane change, and possession of a firearm by a first offender. So I've set bonds on all the other offenses. I'm not allowed to set bond on a possession of firearm by a first offender. So you're going to have a $1,500 bond on speeding, $1,500 bond on reckless driving, $500 bond on concealing the ID of a motor vehicle, and $500 bond on the improper lane change. Bond is going to be denied pursuant to statute 1710-1 on the possession of firearm by a first offender. I'm going to set a preliminary hearing date for September 29th at 8:30 in the morning. I'm going to also set a bond hearing date for October 1st at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
All right, you're free to go back. Is it Mr. Kazal?
Yes.
Okay.
Here you go.
Sir, I understand that there may be a language issue. I've set a bond for you, and that's why I wanted to bring you up. If you don't understand what's taking place, I'm gonna have to continue your case, and you're gonna have to spend the night another night in jail until we can try to get an interpreter. Do you feel comfortable in speaking to me?
Yes, sir.
I've set a bond of $3,000. You're charged with 1 count of simple assault. You can go through a bonding company where you pay a percentage somewhere between 10 and 12% of the $3,000 figure in order for them, as a fee to them, for them to bond you out. There's going to be a stay away provision on the bond to stay away from a Khalat Muhammad Ali. Do you understand that?
Yes, sir.
Okay. Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. But once you bond out, that date will get waived and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay. Do you have any questions of me?
Yes, I got one.
Yes, sir.
And you see the Khalat Ali, she's my wife, and she not driving. And I do working and I'm driving, and I got four kids. I got 2 girls, 2 boys. Sometimes, I take them to school. If they missing us, if they missing a school bus, you got nobody gonna take the children to the school.
So,
I'm sorry, Anna.
No. That's a perfectly valid question.
And she's just like I said, she's not driving. She's not driving car. Just like today or tomorrow, we go to grocery stores. If can I go to my house, who gonna buy the food? Who gonna put the food on the table? Not only for her and for my kids, for my 4 kids. If I'm not gonna do it, no one gonna do it.
I do understand that, and I'm going to answer the question in 2 ways. One, from the legal perspective. We are in charge of making sure that the public is safe. That includes you, your wife, and your children. And so when law enforcement is called out, their job is to make sure that everybody is safe. It's not to say, well, this person is going to be less safe because there's only 1 car. Okay. I choose to believe in all of these situations that this is just an issue of miscommunication amongst adults that can be fixed and can be resolved. But the fact that whatever issue happened between you and your wife brought a judge involved and law enforcement involved, there are rules and things that have to be set down, because I can't sit at your house. I have my own kids I have to take care of. Okay. So we set these really bright lines so that until we can understand it and figure it out, everything can be worked through. I would hope that both you and your wife care enough about your children that y'all will make certain that your children are going to school. This should only be a bump in the road. This should not be a hurdle. This should not be a fence. This is a bump in the road, but it's going to take both you and your wife working together to get it resolved. But because you're listed as the offender and she's the victim, you can't tell her what to do. She has to make choices on her own about what she believes is in her best interest. Okay? So don't place yourself in a position where you could face aggravated stalking charges because you see it one way and she sees it another way. I tell people all the time, there's Lyft, and there's like all of these ride sharing things and all of this stuff that can that can take place so that the children get transported. They can ride the bus. It's a whole lot of things. But what you have to understand is right now, you're currently weathering a storm that will be over one day. And so choose it and see it as a way to make things better so that you're not ever appearing before me again in your life and you're not ever in a jail cell. Okay?
Yes, sir.
All right. Is there anything else, sir?
No, sir.
All right. You're free to go back. Mr. Is it Ladge? Is that the next person you have?
Yes, sir. How you doing, Your Honor?
I'm making it. Sir, you're charged with 1 count of failing to dim your headlights and 1 count of possession of marijuana less than an ounce. There's going to be a $500 bond on the failure to dim the headlights and a $1,500 bond on possession of marijuana less than an ounce. So that's going to be a total bond of $2,000. You believe you can post that bond, sir?
Yes, sir.
There's going to be a preliminary hearing date set for September 28th at 8:30 in the morning. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. You're on the upper end, but I'm going to find that you do qualify. Do you have any questions for me? Okay, you're free to go back, sir. Mr. Morgan?
Yes, sir.
Okay. Mr. West, are you still on? So, Mr. Morgan, we have pre-printed bond forms, and you are charged with 2 offenses by the warrants, but there's only 1 offense listed on the bond charge. So I wrote in the second offense. What I have is driving on a suspended license, but I also have a warrant for a theft by receiving. So I'm going to set bonds on both of these so that you're not languishing in a situation where you're ready to bond out. And I have not set a bond on the other offense. So I'm physically writing it in on the bond order. I'm going to set a $3,000 bond on the theft by receiving and a $1,500 bond on the driving on a suspended license. So you're going to have a total bond of $4,500. Do you believe you can post that bond, sir? The theft by receiving is written as a felony. So you're going to have a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. Is it Mr. Martin?
Yes, sir.
Mr. Martin, sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. You believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Kioshia Treadwell. Do you understand that?
Sure.
Your preliminary hearing date is going to be set for September 28th at 8:30 in the morning. The date will get waived upon your bonding out. Excuse me, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. Mr. Mathis?
Here it is, Your Honor.
Sir, you charge 1 count of driving on a suspended license. The bond is going to be set by schedule at $1,500. Do you believe you can post that bond?
Yes, sir.
There's going to be a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? How much do you make per hour or per month?
1360 per hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. Is it Mr. Mead? Sir, you're charged with 1 count of criminal damage to property in the 2nd degree, 1 count of reckless driving. You're gonna have a bond set at $4,500. Do you believe you can post that bond? I'm sorry?
Yes, sir.
Your preliminary hearing date is gonna be set for September 28th. I'm sorry, 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me?
What's the total bond amount?
$4,500.
That's for both charges?
Yes, sir.
All right.
All right, you're free to go back. Mr. Meadows. Oh, you know what? Can we bring Miss Mead back?
Would you ask for, Your Honor?
Mr. Mead, can we bring him back? I failed to ask if he wanted a lawyer.
Yes, sir.
Do you want me to see if you qualify for the appointment of lawyer?
Yes, sir.
Okay, you do qualify, Mr. Mead. I'm going to appoint a lawyer to represent you. Now you're free to go back, sir.
Mr. Meadows.
Mr. Meadows. Sir, you're charged with 1 count of theft by receiving stolen property. The bond is going to be set at $10,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I have one, Your Honor.
Okay. Do you have any questions of me, Mr. Meadows?
No, sir.
Okay, you're free to go back, sir.
Thank you.
You're welcome.
Miller.
Mr. Melton, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act. Bond is going to be set at $3,000 for that. 1 count of possession of firearm during the commission of a crime. Bond is going to be set at $5,000 for that. And 1 count of driving a vehicle with no tail lights. Bond is going to be set at $500 for that. So that's going to be a total bond of $8,500. You believe you can post that bond, sir?
Yes, Your Honor.
There's going to be a preliminary hearing date set for September 29th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
You repeat the total balance of the bond.
So the total amount is going to be $8,500. There's going to be a fee added by the sheriff's department that they're required to do by Georgia law. So it's going to be a little bit higher. But you can go through a bonding company.
Yes, Your Honor. Thank you.
You're welcome. You're free to go back, sir. Are you Mr. Is it Muir? Mauer. Mr. Mauer, sir, you're charged with 1 count of driving on a suspended license and 1 count of failing to yield at a stop sign. You're going to have a total bond set at $2,000, $1,500 for the suspended license, and $500 for the failure to stop at the stop sign. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Good evening, Your Honor.
Okay, wait, I'm sorry, tell me your name again.
Nasiri, first name Paimon.
Okay, so Mr. Nasiri, you're charged with one of these offenses that under Georgia law, I cannot set bond for at this time. So anything over 10 pounds of 10 pounds in weight of marijuana, and it's charged as trafficking, I cannot set bond. I'm going to set a preliminary hearing date for September 29th at 8:30 in the morning. I'm going to also set a bond hearing date for October 1st at 8:30 in the morning. Now, do you plan on hiring your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
Yeah, I'm see if you can hire one or something, because I mean, the situation I'm in, I've never been before, you know, and I do take care of my whole family, you know, and I have kids and my wife doesn't drive back home, so just the situation I'm in is in a bad situation, and I'm just want to know, is there anything else you can try to help me with?
So you do qualify. I'm going to appoint a lawyer to represent you, but I'm going to tell you this. Today is Friday. It's been over 200 pounds of marijuana that I've seen of people in your exact same position during this week. And it happens week after week after week. And the TSA, prior to your plane even taking off, they know what's going on. I don't know who's recruiting people, who's saying what they're saying, but primarily it's people that come before me that if it wasn't an offense that I could not set bond, I would set bond. But there are people who, in my opinion, are being led astray, and they don't know it until they come before me and they realize that they have to sit in jail. So your lawyer, or if your family can hire a lawyer, they can negotiate and they can sit down and talk with the district attorney's office. The fact that I can't set bond today does not mean you can't get a bond set tomorrow, but it'll have to be through a consent agreement with the prosecutor until it works itself up to a bond hearing date.
Right, it just, I have a disabled mom at home too, she's epilepsy, so I take care of her, you know, I work for her, so there's just things that I'm just trying to figure out, you know, like I said.
So what I'll say to you, Mr. Nazariri, is that my typical response to people when they say that is that you had a disabled mom when you got on that airplane. So when you try to use that as like, hey, I got a disabled mom that I'm taking care of, it's like, well, a judge could say, well, you're not doing a good job of it because you're sitting here in a jail in Clayton County and she's out in California, correct?
Correct.
So you're not doing a good job of it.
Okay.
So you have to understand, it's not that I'm unsympathetic, but I can't set bond. My hands are totally tied. And the decisions that you made have added to your being here. So try to work with the lawyer, either one through an appointment or hiring a lawyer to help get yourself out of the situation, because you can. You can get yourself out of it, but it's not going to be through a pity party kind of deal. Okay. All right, sir. You're free to go back. Do we have is it Mr. Rudd next? Or Mr. Roberts? Who we have next? You're Mr. Roberts? Mr. Roberts, sir, you're charged with improper passing, too fast for conditions, improper passing in a no passing zone. and reckless driving. You're gonna have $1,000 bond set on it. Actually, no, $500 bond set on both of the improper passing charges, $500 bond set on too fast for conditions, and a $2,000 bond set on reckless driving. So what that means is that you're gonna have a total bond set at $3,500. You believe you can post that bond, sir? You're gonna have a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of lawyer?
Yes, sir.
Okay, you do qualify. Mr. Roberts, I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir? Okay, free to go back. Okay, Rudd, did I hear Rudd?
Yes, sir.
Okay, sir, you charge, I'll ask it this way. Do you know what you're charged with?
Yes, sir.
Okay. I'm gonna set a bond for $10,000. Do you believe you can post that bond?
Yes, sir.
There's gonna be a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Okay.
Okay, you're free to go back. Mr. Sutton, is that the next person? And the reason I ask is because a lot of times the alphabetation is kind of out of order. So I set it up on based upon the list that I get from the sheriff's department, but I'm flexible to do what you need me to do.
This is DeAndre Smith.
Okay. Mr. Smith, sir, you're charged with one count of violation, Georgia Controlled Substance Act. Bond's going to be set at $3,000 for that. One count of use or possession of drug-related objects. Bond's going to be set at $1,500 for that. One count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. Window tint violation. Bond is going to be set at $500. And possession of firearm by a convicted felon. Bond is going to be set at $5,000. So you're gonna have a total bond set at, what's that, 10. Looks like at $16,000. I'm sorry. I tell people it's my public school math. $16,000. You believe you can post that bond?
Yes, Your Honor.
You're gonna have a preliminary hearing date set September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
All right. How much do you earn either per hour or per month?
Per hour, I earn $17.50 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back.
One more question. You said the total was 16,000?
Yes, sir. Hold on 1 second. Because as I'm checking my math, let's see, we're gonna do 10, 12, 15,000.
15,000?
1-5.
Okay, thank you, Your Honor.
You're welcome.
Now I have Q-Ron. Say your name. Ron Smith.
Okay. Sir, you're charged with one count of possession of marijuana less than an ounce, bond set by schedule at $1,500. Do you believe you can post that bond?
Yes, sir.
You're gonna have a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. I got a quick question.
Okay, give me 1 second. All right, you're on the top end. I'm going to appoint a lawyer to represent you. What was your question, sir?
I was told like last night they we were bonded out by magistrate court. I mean, not magistrate court, but a bail bond. And like I didn't hear anything. Nobody that knows that came and pulled me and I ain't hear nothing else about it. But I seen the money taken out of my account.
Okay, so your offense is one that is immediately bondable. The way that I want you to think about this whole operation, because it started out with, I think, 56 people on the calendar, and I think we ended up with 49.
Yes, sir.
It's a big old ship that has to turn around. So there are people that have posted bond that get placed on my calendar. There are people that I'm ready to see that they bonded out. So you just got caught within the middle part. And that's as simple as I can explain it. So when you leave this hearing, you're probably going to knock on the door telling you, pack your stuff and go. Okay?
Yes, sir. Thank you.
You're welcome. You're free to go back. Are we with Mr. Sneed? Sutton? Okay, Mr. Sutton, sir, you're charged with failing to register. Bond's gonna be set at $10,000. You believe you can post that bond?
No idea.
Okay, there's gonna be a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, you're free to go back.
Mr. Sneed. Mr. Sneed. It's Mr. Sneed, y'all.
Okay, Mr. Sneed, you're also charged with one of these offenses, trafficking in marijuana, that I cannot set bond for. So bond is going to be denied at this point. I'm going to set a preliminary hearing date for September 29th at 8:30 in the morning. I'm going to also set a bond hearing date for September 1st at 8:30 in the morning.
September 1st or October 1st?
I'm sorry?
You said September 1st or October 1st?
October 1st for the bond hearing, September 29th for the preliminary hearing. You're in the same position as Mr. Nasiri. I cannot set bond. Does not mean your lawyer can't negotiate with the district attorney and have a consent bond set. But this is going to be something that's going to have to go through the district attorney's office. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah, but
Okay, I'm going to appoint a lawyer to represent you. If you decide to retain a lawyer, just let the appointed lawyer know.
okay, that's what I was gonna ask.
Yeah, yeah. Okay, anything else, sir?
No, sir.
Okay, you're free to go back. Okay, sir. I'm gonna set bond on this offense at $10,000. I'm gonna place a stay away provision on the bond, stay away from Kelly Williams. Do you understand that? Your preliminary hearing date is gonna be set for September 29th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I'm sorry.
You're gonna hire your own lawyer?
Yes, sir.
Okay. I'm sorry. And it was me, it wasn't you. I got myself confused. Do you want me to see if you qualify for the appointment of a lawyer?
He said, yes, Your Honor.
Okay. All right, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Is my charge a misdemeanor or felony?
It's a misdemeanor. Okay. Anything else, sir? All right, you're free to go back.
Bond. Mr. Bond, how you doing?
Yes. Sir, you're charged with one count of driving a vehicle without a license and one count of driving a vehicle with an expired tag. Your total bond is going to be set at $1,500, $1,000 for the license and $500 for the tag. Do you believe you can post that bond, sir? You're going to have a preliminary hearing date set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Mr. Washington. Jesse Washington.
Okay, sir, you're charged with one count of simple battery, one count of criminal damage to property in the first degree. You're gonna have a total bond set at $8,000, $3,000 for the battery and $5,000 for the criminal damage to property in the first degree. Do you believe you can post that bond? You're gonna have a preliminary hearing date set for September 29th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? All right, I'm going to find you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Mr. Washington, pronounce the first name.
Sorry.
Okay, Mr. Washington, sir, you're charged with simple assault and criminal damage to property in the second degree. You're gonna have a $3,000 bond set on the simple assault charge and a $5,000 bond set on the criminal damage to property in the second degree charge. So that's a total bond of $8,000. Do you believe you can post that bond?
Yes, sir.
There's gonna be a preliminary hearing date set for September 29th at 8:30 in the morning. The date will get waived upon your bonding out and you'll get a new court date in the mail. I'm also going to place a stay away provision on the bond to stay away from a Jesse Washington. Do you understand that?
Yes, sir.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm sorry, sir.
Yes, sir.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Mr. Wheatley, Your Honor.
Okay. Mr. Wheatley, sir, you're charged with one count of violation of Georgia Controlled Substance Act and one count of driving under influence. Your bond is going to be set at $3,000 for the violation of Georgia Controlled Substance Act and $5,000 for driving under an influence. So that's a total bond of $8,000. Do you believe you can post that bond?
You said, what was the first charge? Your Honor, sir?
Possession of methamphetamine.
Don't discuss it.
Yeah, wow, okay, I understand.
So, Mr. Wheatley, that's the charge. You're presumed innocent. It's my duty to tell you what you've been charged with so you can prepare a defense, okay? This is not the time to talk about guilt or innocence, okay? So, do you believe you can post a bond?
Yeah.
Okay. There's going to be a preliminary hearing date set for September 29th at 8:30 in the morning. The date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, ma'am. Yes, sir.
How much do you earn either per hour or per month?
Hour 1850.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, so you said $8,000, right?
Yes, sir.
All right, thank you.
Okay, here to go back.
Mr. Wilson. Mr. Wilson. Mr. Wilson, Your Honor.
Mr. Wilson, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
Was that a yes or a no, Mr. Wilson? Do you believe you can post that bond?
$3,000?
Yes, sir.
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Shante. It looks like either house or housey. I can't understand the writing. Do you understand that?
I hear what you're saying, but I don't understand how I'm with my wife.
Okay, I'm going to come back around and I'm going to ask you some questions, okay? Your preliminary hearing day is going to be set for September 28th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. So the purpose of the stay away provision is to keep you and Miss Housey or Shante separate until this whole thing can get worked out. Do you understand that?
Yeah.
Do you have any questions about that? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, I can't believe you ain't asked me what kind of job I have. I mean, I ain't got no question, but I just, you asking people about jobs, and I got one, you say you didn't have allowed, you can ask them about it. That's all I'm saying.
So just so you know, Mr. Wilson, sometimes people don't fill out the forms completely. So they'll say, either they'll leave a spot blank.
Okay.
So that's when I ask a question, that's where it's based upon. You filled your form out, so I did not have to ask you any additional questions. All I need to know is whether you wanted a lawyer or not. Then I could say yes or no. All right, sir?
Yes, sir.
Okay, have a good day.
Your Honor, before you leave, I have someone here that needs to ask you a question.
Sure. Hold on. Let me